Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner, and in this video, we're taking a high-level overview look at the PERM employment-based green card process. A couple things to keep in mind before we take a deeper dive into this overview of the process. One is that the PERM labor certification process can have a person fall into the EB2 or EB3 classifications. The EB2 classification is for positions that require a master's degree or equivalent. Equivalent here means a bachelor's degree plus 5 years of progressive work experience. EB3 positions are for positions that require a bachelor's degree or at least 2 years of experience. Positions that require less than 2 years of experience would fall into the skilled worker category. The other thing to keep in mind is the standard for the PERM labor certification process. The standard is that the employer has to show that there are no U.S. workers who meet the minimum qualifications for the position. That means we are not looking for the best and brightest or the person who is most qualified for the position. Unfortunately, we are looking to see the employer has to show that there are no U.S. workers who meet those minimum qualifications. I'm going to share my screen and we'll take a look at the 3 stages. So there are 3 major stages. The first is the PERM labor certification application process. This first stage is all processed through the Department of Labor, a different agency from USCIS, where stages 2 and usually 3 are processed. As I said, the reason that the employer has to go through the PERM labor certification process is to show that there are no U.S. workers who are willing, available, or qualified for the position. And again, we're looking at minimum requirements. What's actually required is a minimum requirement, not what's ideal to have, not what's preferred, not what most people have, but what's the minimum requirement. That can be tricky. In order to show that there are no U.S. workers who meet the minimum requirements, the employer has to follow a very specific series of steps that are dictated by the Department of Labor regulations. We'll be going into those steps, some of those steps in a bit more detail, but keep in mind that it is a very detailed process with a lot of different requirements. And we walk employers through that step by step by step so that you don't have to worry about it. We make sure that everything is done in compliance with the regulations. So one of the things that we have to do is obtain what's called a prevailing wage determination. We'll be talking about that in subsequent videos. Then we have to conduct the recruitment. The recruitment is done according to regulation. It is not real life recruitment. So for example, the regulations require as one of the recruitment steps that the employer place an ad in the Sunday newspaper. So the print newspaper that almost no one gets, but that is one of the requirements. In addition, there has to be a job order, there has to be a notice of filing, and then if the position is a professional position, meaning one that requires a minimum of a bachelor's degree, the employer has to take some additional recruitment steps as well, at least 3 of a set of 10 of alternative recruitment steps that they have to take. Once the recruitment is done, the employer will, or as it's ongoing rather, the employer will have to review any resumes or applications that they receive and conduct interviews if needed. Again, we'll be talking about that in more detail in future videos. Assuming the employer finds that no U.S. workers meet the minimum requirements for the position, then we can file the 9089. That's the name of the form that is filed online with Department of Labor. We file it online and we don't submit supporting documentation. It's not permitted even to submit the supporting documentation. We do have to keep a file of that in case Department of Labor asks for it later in the event of an audit, but we don't submit it with the application that we upload to the Department of Labor website. The Department of Labor then reviews everything, and once they have confirmed that everything is satisfactory, they certify the application. The processing times that you're seeing on the screen here are approximate processing times as of the time that this video is made, but they are subject to change for better or for worse. Once the Department of Labor certifies the PERM labor certification, the Next step is the employer will file what's called an I-140 petition. This is filed with USCIS. The purpose of the I-140 petition is the employer has to show that the position is available, so that's a letter from the employer, that the foreign national beneficiary meets the minimum requirements for the position. So that's things like copies of their experience letters, their degrees, transcripts, any certifications or licenses that are required for the position. And finally, the employer has to show that they have the ability to pay the proffered wage or the prevailing wage, which we'll talk about again in a subsequent video. Each of those pieces is tremendously important, and we actually lay the groundwork for that in the PERM labor certification stage, preparation stage of the process. So when we begin the process, we ask for documentation. The reason we're asking for that, for these experience letters and the tax returns and things like that, is because we want to make sure that the foundation is strong and that we're going to be able to have all the documentation we need for the I-140 petition down the road. So we put everything together with the I-140 petition. We submit this petition along with the certified PERM. So the employee will sign the PERM, the employer will sign it, the attorney will sign it, and we submit everything to USCIS. Once we submit everything to USCIS, right now, again, these times are subject to change. Right now, it's taking about 6 to 12 months for USCIS to process these. It is possible to use what's called premium processing. That is when you submit an additional government filing fee to USCIS, and they will make a decision or issue a request for evidence within 15 business days after receiving it, or you can just use regular processing. The final stage in the process is the application for adjustment of status if the foreign national employee is here in the United States and valid immigration status. So for example, if the employee is working on L1A, L1B, H1B, for example, then they likely would file for the adjustment of status. It's possible in some situations that the employee is working overseas, or that for another reason, sometimes a strategic reason, immigration strategic reason, we have selected in confirming with the, in concert rather with the client, we have selected consular processing, which is when a person applies for the immigrant visa overseas. Regardless of whether you are seeking, whether the foreign national is seeking the immigrant visa overseas or the adjustment of status, this stage is really all about the foreign national. So we file this process for the employees as well. We help employees with this process as part of our services, but it's really information all about the employee. So we submit things like their work history, their employment history. This is when the family members can be added to the process and would apply for their own, submit their own I-485. This is the stage at which a person can apply for a work permit and a travel document as well. One thing to keep in mind with the I-485 stage or consular processing is you cannot file the I-485 until your priority date is current. We have an earlier video on the priority date if you're wondering what that is, but the priority date has to be current for the I-485 to be filed. Once the I-485 is filed, again, processing times really vary, so I'm hesitant to even talk about it in this video. But know that the priority date has to continue to be current per final action in order for the green card to be approved. With consular processing, again, the priority date has to be current per final action for the green card to be approved. Once the green card is approved, then the employee can work in the United States. They no longer need their underlying non-immigrant status, like their H-1B or their L or E or TN or whatever they were working on before. They'll work using the green card. We will have a separate video on issues that talk about how long the employee has to stay with the employer and considerations like that. But for now, this is a high-level overview of this intricate process. Again, my name is Emily Sumner with Sumner Immigration Law. We serve clients throughout the United States and around the world with employment-based and family-based immigration matters. In our next video, we will be taking a closer look at the prevailing wage request process. I hope that you'll subscribe to this platform and make sure you don't miss our next video and share this one with a friend. Until next time, I'm Emily Sumner.